Hello friends, how are you? Today I am going to discuss an important perspective regarding the protection of women from domestic violence act. Usually we see that the wife on concocted basis initiated the proceeding, and later on when the compromise is taken place and complaint is withdrawn and again she resumed the cohabitation with the husband, she might be on the concocted basis may lodge a second complaint by concealing the material facts. In that condition, the major perjury is caused to our rights. What we should do, whether the previous factum of compromise or settlement or previous filing of the complaint under the Protection of Women from Domestic Violence Act is liable to be considered or not. In that connection, recently a legal position has been propounded, in which it is held that if such scenario occurs, then the court is bound to consider the same. So first we have to understand the facts, then the rival contention of the party, and then the legal position laid down by the Honorable Supreme Court, so that if we are having the same trouble, we could easily use the guidelines and could obtain the relief as per law. Friends, please note down the material fact which I am going to narrate you. In this case, a petition is filed before the Honorable High Court to challenge the impugned proceeding initiated against the respondent under Section 12 of the Protection of Women from Domestic Violence Act. In this case, the major point is that the concerned petitioner is married with the respondent on a particular date. After marriage, a child is born, and it is the basic complaint of the husband that from the inception of the marriage, the behavior of the respondent is not good towards him, and she wanted to live separately. And apart from that, she has subjected the petitioner and his family towards severe atrocities. In the meanwhile, the efforts of the conciliation is done, and the concerned respondent resumed the matrimonial relationship with the concerned petitioner. Subsequent to this, all efforts failed, and finally, the petitioner has filed a divorce petition against the respondent on a particular date. As a counterblast, she has filed a case for the Protection of Women from Domestic Violence Act before the concerned magistrate. In the said application, she has averted the false application, and subsequent to this, the compromise has been occurred between the parties. These are the major points and factual score concerning the present case. Friends, it is further contended that on same cause of action, the concerned respondent again filed a DV case, and this time the earlier facts were reproduced, and that's why the same was considered by the petitioner as an abuse of process of law, and that's why he has filed the concerned petition before the High Court on the ground that the factum of earlier settlement, earlier complaint under the DV Act has been deliberately concealed, and that's why it is liable to be quashed, and the remedy is to be provided in favor of the concerned petitioner. The same was opposed by the concerned respondent on the ground that there is no concealment. Subsequent to the resumption of the matrimonial house, she was again subjected to the severe atrocities, and that's why she is totally competent to file a new case under the DV Act, and apart from that, the earlier settlement will not affect the right of the respondent to file a new case. Friends, now I am going to tell you the important observation of the court. Each and every line is important for us. If you want to enforce your legal right, you have to understand what the Honorable Court had dictated in its judgment. The court at para number 10 specified that the petitioner in effect are aggrieved by the impugned petition filed by the respondent wife against them, and as far as the proceeding of Section 12 of DB Act is concerned, the same could not be equated with filing of a criminal complaint or initiation of the prosecution. So the trial magistrate, after obtaining the response from the husband or his relative, is well within jurisdiction to revoke the order of issuance of summons, or even he could drop the proceeding. The court also supported the view in light of judgment laid down by the Honorable Supreme Court, cited as 2022 SCC Online Supreme Court page 446. In this case, it is observed that the scope of notice under section 12 of the DV Act is to call a response from the husband. Apart from that, the court specified that if after receiving the version of the husband or his relative in a proceeding under section 12 of the DV Act, the magistrate comes to a conclusion that no case is made out, he could drop the proceeding or he could recall his earlier order of giving any compensation in favor of the concerned respondent. In the present case, the court has specified that the magistrate, while issuing the notice to the concerned petitioner, awarded the interim monetary compensation in favor of the wife. It is clearly indicated that the concerned petitioner are at liberty to approach to the court for the modification or alteration of the said order. It would be open for the petitioner to file their reply to the main petition. Once it is done, their submission is to be considered by the court, and if the court finds that no case is made out, the court is competent to recall the order and to drop the proceedings against the petitioner. So, the court specified that while doing the justice, the court is required to hear both the parties. The court is required to hear even the response, even the reply of the concerned petitioner, and if court finds that no case is made out, the court is totally competent under the provision of section 12 of the DV Act to recall its previous impugned order. So friends, if you are having the same trouble, your wife concealed the material fact, or she is in habit to obtain the ex parte order by playing the foul practice, then don't worry. This legal position could help you. Friends, just file the petition before the court with a prayer to recall or to modify or to alter the previous impugned order passed in the ex parte manner. If it is not altered or revoked, in that scenario, you may approach to the Honorable Sessions Court by the way of appeal as contemplated in section 29 of the DV Act, or further you may approach to the Honorable High Court for the vindication of your grievances. So don't be disappointed. There is a way, but the thing is that we have to exercise it in the prudent manner. Friends, if you like this video, just share it. See you soon. Till then, Jai Hind, Jai Bharat.